Hey folks, Eric here, the Whatever Guy, because it really is whatever me. And do you folks want to know about this lawsuit, this third biggest lawsuit that the AMCC, the Alabama Medical Cannabis Commission, is facing? You guys stick around, man. I'll talk to you guys about that. As you guys know, man, my name's Eric. I'm the Whatever Guy. I use videos a couple days a week, basically keeping you guys updated in the world Delta 8, Delta 9, Delta 10, hemp cannabis, just what's going on around. And having said that, man, today, sitting here bullshitting around on an early Monday morning, excuse me. This weekend, man, I messed around and was messing around with some knives, doing some work, and it is slicing my fingers. So I've got a couple slices going on here and a couple slices going on here. So it's been a crazy weekend all the way around. But we're going to talk today about this, the Alabama Medical Cannabis Commission. As you guys know, back in 2017 or 2019, they actually made medical cannabis, brought that legislature forward so that we could get to a position in 2023 where we would be issuing the licenses and actually getting towards getting some of these people in the state of Alabama some good medical marijuana. But having said that, the process has been screwed up since day one. As you guys know, on June 10th of this year, they awarded those licenses, and within a couple of days, we realized we had a lot of issues. They re-awarded those licenses again, I think, in August, and obviously the second awarding of the licenses brought forward a bunch of other lawsuits. This lawsuit here is the third lawsuit, or actually the biggest lawsuit of all the lawsuits that are coming forward, will be the one that we're going to talk about today. And it simply just outlines all the inconsistencies and everything that's going on with the AMCC. Now, for those of you out there that are sitting on both ends of the board, there's actually several different factions that are actually pushing to get this medical marijuana going in the state of Alabama. You've got people that are advocating for patients' rights. You've got people that are advocating for the processors' rights, the people that are making the marijuana, and then you got this AMCC sitting up here changing rules as they go along. But having said that, there's been a big argument. There's a lot of people in that are on the other side of the fence that are basically telling us to drop all these lawsuits. But what you're not understanding is that a lot of these, we've got 90 applicants, and out of those 90 applicants, all those people spent upwards of $1 million to get to a position where they could even be awarded a license. And for them to get to the other end of it and find out that it's all fucked up and that the AMCC just awarded their friends licenses is a really screwed up situation. Well, this lawsuit that we're going to talk about right here is Alabama Always. William Somerville is actually the lawyer for Green Phoenix also, which is Boro Hemp, the company I work for. But having said that, this is going to outline exactly what's going on with the AMCC. Now, these lawsuits that came forward, this lawsuit that we're talking about here actually came from the discussions of the previous lawsuit. So what we're moving forward to now is a position where we may be a long ways off with getting medical marijuana for patients or for anybody that's in the manufacturing side of it, simply because if you talk about Alabama Always, they themselves put out $7 million to put up an integrated facility for you to just go in there and award and take that license away from them and award it to one of your buddies. And that's basically what this is outlining in this article right here. So we're going to switch over to the Alabama Reporter. We're going to take a look at this, and it says Alabama Always seeks court intervention against Cannabis Commission's licensure decisions. We'll scoot down here. Medical cannabis producer Alabama Always on Friday filed legal action against the Alabama Medical Cannabis Commission in Montgomery County Circuit Court, requesting a temporary restraining order and preliminary injunction. The company seeks to halt the commission's current licensing process, which it claims relies on an illegal scoring system. The firm advocates for a more transparent application process, adherence to the Darren Wesley Alto Hall Compassion Act, and ensuring applicants meet specified requirements before being awarded licenses. In the new court filings, these are new court filings, like I said, if you have to understand that after August 10th, when they awarded those licenses, these people have been in conversation since that time. So now we're sitting, October 9th, in the middle of October. So 2 months that they've been talking about this, or we'll call it a month and a half. And basically, this is the lawsuit that came from the discussions after the fact. Like there was already previous lawsuits before August 10th. There was another lawsuit filed on August 10th, but this lawsuit basically encompasses everything that has happened previous to this. In the new court filing, Alabama Always argues that the Compassion Act was enacted with the primary intention of swiftly making medical cannabis available to those in need in Alabama. The statute mandates that to acquire a license, a firm must demonstrate its capability to begin cultivation within a short 60-day time frame after approval. Alabama Always alleges that the commission deviated from its initial rules and, without proper public input, introduced a new scoring system that overlooked the actual capabilities of applicants, focusing more on detailed documentation. The lawsuit contends that the revised scoring methodology overly emphasized complex paper submissions, neglecting the primary mandate of the Compassion Act, prompt cultivation readiness, according to the company. This alleged oversight resulted in awarding licenses to ill-equipped firms, further stalling the provisions of the medical cannabis to waiting patients. Alabama Always accusations don't end there. They've highlighted discrepancies in the commission's scoring approach, including inconsistent grading among evaluators, irrelevant scoring metrics like vehicular specifics, and an impractical 10 megabyte restriction for application files, which reportedly caused multiple technical disruptions. Furthermore, the lawsuit emphasized the company's commitment to the initial expectations, having invested over $7 million in an advanced integration production facility with capabilities to initiate cultivation within a mere 15 days of receiving a license. Alabama Always accentuates its alignment with the Compassion Act's core intentions. Now, this is the argument. This is the argument for you people out there that are sitting on the side of the patients. These people, these 90 applicants that put in the applicants had to have all of this stuff ready to go before they ever put the application in. These people were spending millions of dollars, hundreds of thousands of dollars to get buildings, to get equipment, to get everything set up for you to come back and say, I'm just going to give this license to one of my friends, and we're not ever going to talk to you. Like the whole thing is messed up. Like, what they should have done was just awarded all of the license and allowed the market to sort it out, because just like this lawsuit points out, there's no way that the majority of those people are going to be able to get a product on the shelf in 60 days. It's not possible. So out of all those 90 applicants, I would imagine that probably 15 to 20 of those applicants in the different spaces would have been able to get some sort of product up on the shelf within 60 days. I myself, I'm not sure that Green Phoenix could have got up on 60 days. I'm pretty sure we would have been real close to it. But that is the initial argument right there. It is in its filing, Alabama Always also contends that the commission's actions violate the Alabama Administrative Procedure Act by not providing proper public notice and not adhering to rulemaking protocols. The filing argues that several of the commission's actions, from the rollout of application guidelines to the introduction of specific scoring metrics, infringe on the AAPA statutes. Moreover, even if these rules were lawfully set, they seemingly clash with the Compassion Act's directives, according to the Alabama Always lawsuit. As a remedy, Alabama Always advocates for a total overhaul, annulment of the commission's previous licensing determinations, abandonment of the current scoring methodology, and establishing a system in line with the Compassion Act's original intent. They also push for unmasking applicant data to ensure transparency and fairness in the evaluation process. Alabama Always says this legal challenge isn't just a corporate tussle, it's about safeguarding the broader public's welfare. With medical cannabis being a lifeline for many Alabamians, it's paramount to expedite its accessibility, embodying the Compassion Act's aspirations. The company maintains that whether it's through legal adjudication or mutual settlement, the focus remains clear: instituting a license system that's just, transparent, and most importantly, aligned with the needs of Alabama residents is the only path forward. The suit lays out specific remedies the company is seeking: declaring the commission's award of license at its June 12th and August 10th meetings null and void, enjoining the use of the scoring process, including exhibits from the applications, because the entire scoring process creating an unnecessarily complicated and daunting system that frustrated the requirements of the Compassion Act, enjoining the use of scores resulting from the process of instructing the commission to ignore prior scores related to the scoring process, requiring that the commission devise and follow a system that properly evaluates the Compassion Act's intent, requiring that the commission, all other things being equal, award licenses to applicants who, in its judgment, demonstrate the ability to commence operations and reach full capacity the earliest, declaring invalid the rules set out by the second amended complaint, including but not limited to the commission's 10 megabyte limitation. For those of you who don't understand the 10 megabyte limitation, when they put in all the applications and all the information that they wanted to put in, they gave them a 10 megabyte cap. Like, they couldn't, all the pictures and all the information that they wanted to put into these applications probably would have equaled up to 1 terabyte, but they limited them to 10 megabytes, which really created a situation where you couldn't figure out which companies could actually get medical marijuana up in about 60 days. Requiring the commission to adopt rules and regulations in compliance with AAP, requiring the commission to enforce the Compassion Act, requiring the commission to unredact all application information, which that's another thing thing too, by the way. If you go into the AMCC, amcc.com, and you go in and look at the applications, you'll notice that a lot of the information is all blacked out. All of that stuff was supposed to be transparent because it boils down to making sure that people from Alabama were the ones that benefited from the medical marijuana program. And what you found out at the August 10th meeting and the June 12th meeting was that they actually awarded companies licenses that were not based in Alabama. One of them had a license that was tied to some address in the Netherlands. And obviously, we've got the Verano situation where they've come from Chicago down to Alabama. Those type of licenses should have been wiped out. It should have been people that were actually from Alabama that had been living in Alabama would be benefiting from this program. Requiring the Commission enforce the Compassions Act requirement that licenses have attained a $2 million performance bond, requiring the Commission to unredact all application information, prohibiting any future meetings of the Commission, including discussions of applicants and applications in open or closed sessions that fail to comply with the AAP's contested case provisions. That's another thing. They want all these meetings to be held in the open. Like if you guys go to the last couple meetings they had, what's happening there is they actually will talk about the first 15 minutes and then they go up in the closed door session, and when they come back down they award the licenses, and that's not cool. That's not cool at all, because in reality what's supposed to happen is they were supposed to do this all out in front of everybody, let everybody know what's going on, and they're not doing that. Awarding Alabama always costs, interest, and other equitable and or legal relief to which it is entitled. The other thing too is, like I said, guys, what you have to understand on the backside is that all these 90 applicants that put in these applications, you have to remember that when they put these applications in, they had to have all this stuff in place. So if you were applying for an integrated facility license, you literally had to have the building and everything inside of it ready to go, ready to work before you even applied for this license. So the license itself, I think, was $150,000 for the application, not to mention the other $7 million that was spent on the facility to get it ready to go, just for us to get up to the Alabama Cannabis Commission and for them to tell us, okay, you're not getting a license. How are they supposed to, what are they supposed to do with all that money they lost? Like we just poured $7 million into the state of Alabama getting a building and all that shit set up, and basically you're telling me that we can't do any business. The legal motion by Alabama always underscores the importance of adhering to established procedures when introducing and managing medical cannabis legislation. And that's what's going on here, guys. Like none of the rules that were laid down have been followed since day one. Like people that were, Verano getting awarded a license, people in the Netherlands getting awarded a license. All these people that are from Alabama have spent good money in Alabama to get medical cannabis going. Let's just go ahead and get it going. Let's award the licenses to the people in the state of Alabama and get it going, guys. Like this is ridiculous. But this lawsuit right here, guys, is probably going to push us a lot further along. But I'm really happy that it actually opened the eyes of some of the people that are reading this to understand that all those people that are putting those applications in are not trying to keep medical cannabis out of the hands of patients in Alabama. They're just trying to get some sort of resolution on the other side. If you spent $7 million to set up and get ready to do business and find out on the other side that the whole process was screwed up in the beginning and they awarded the license to all their fucking friends, you wouldn't be too happy about it either. Okay. And that's where we sit with the situation right now. All right, folks, this is Whatever Guy signing off. Hope having a great week. I apologize for being jawed up this morning. It's a little bit early and it's cold out, and I will talk to you guys later, man. Love it. See ya.